Hello everyone, this is Lizard World. Today I am here to discuss with you about POCSO Act, Protection of Children from Sexual Offences Act. This act came into force in India in 2012. Before going deep into this act, we want to know what was the necessity of the act. Actually, before 2012, there was no act which specifies the sexual harassment to children. And even the then existing act does not cover sexual assault or sexual harassment or sexual offences against children. And even male children were not covered under any of the existing laws of that time. So it is very important, it's very important for such a law to get enacted. Now, coming to the POCSO Act 2012, it covers six different types of offences against children. First one, penetrative sexual assault. Second is aggravated penetrative sexual assault. Third, sexual assault. Fourth one, aggravated sexual assault. Fifth one, sexual harassment of children. And sixth one, use of child for pornographic purposes. So, what is penetrative sexual assault? Look, it's an offense where the penis or any other object or any of the body part is penetrated to any extent into the vagina, anus, mouth, or urethra of the child. Or the child is made to do the same to the perpetrator or any other person. This is penetrated sexual assault, but it also covers the use of mouth or touch by the mouth into private parts of the child. That is penetrated sexual assault. And what is sexual harassment? Sexual harassment means a kind of using of words or gestures or language with a sexual intent on the child or making the child to watch doing him or touching him any private part. In this, the online sexual harassment is also contained where the child is made to watch pornographic material. And what is use of child or children for pornography purposes? It means where the children are used in any kind of recording like an audio-visual medium for pornographic material. So that's use of children for pornographic purposes. Now, we have discussed the plain meaning of what is penetrated sexual assault, sexual harassment and use of children for pornographic purposes. Then what happens when it gets aggravated? Or what is meant by the aggravated penetrated sexual assault or aggravated sexual assault? Such offences become aggravated when it is committed by a person in possession of trust or authority. For example, if it is done by a police officer or any government servant or any official or officer, it will fall under the purview of aggravated. And also, if the offence was committed by the people of medical institution, jail, or remanded home, or the observation home where the child in need of care and protection is kept, or any other childcare institutions, are also on the purview of aggravated. And also, the aggravated comes when it's a gang assault or the child is caused a grievous hurt or causes physical or mental disability, or the offense is committed to a child who is taking advantage of child's mental or physical disability. Or once a crime is committed, a sexual offense is committed, and again it is repeated, or the child is below 12 years, or when the offender is a relative of the child, or there's a kind of attempt after the commission of sexual offense to murder the child. There's an attempt to murder the child after the sexual offense, or made to strip or parade naked in the public, and or it is a case of storing pornographic material involving a child, and these all come under the aggravated form of the penetrative sexual assault or aggravated sexual assault, etc. Now, what are the punishments given in case of these six different types of offences against children? In case of a penetrative sexual assault, the punishment given is 7 years of imprisonment, which may extend up to life imprisonment as the case may be, and with a fine. And it is amended, and now it is like even death penalty can be given for such an offense. Now, what in case of aggravated penetrative sexual assault? Here, the imprisonment is up to 10 years, and which may extend up to life imprisonment, and also with a fine, accompanied with fine. And in case of sexual assault, 3 years imprisonment, which may extend 5 years plus fine. And in case of aggravated sexual assault, it is 5 years imprisonment, which may extend to 7 years along with fine. And in case of sexual harassment of child, it is 3 years imprisonment and along with fine. If it is use of child for pornographic purposes, then the punishment given is 5 years if it is done first time, and if it is again committed or it is repeated, it will be 7 years imprisonment. Now, the thing to be noted is that storing the pornographic material which involves a child is also punishable under this act. The punishment will be 3 years of imprisonment. And another thing is that in such cases, actually, if an offense is committed, the burden of proof to prove that such an offense is committed is on the victim. But in case of this kind of sexual offenses against the children, the burden of proof is shifted on accused in case of serious offenses. That's all about the 6 different categories of sexual offenses against children. Now, what is abetment? Or what is abetment in case of sexual offenses against children? Abetment is also treated very seriously. It is treated with the same gravity as commission of that offense. Even the trafficking, that is the movement of children for sexual purposes, is also covered under abetment. And any attempt to commit any sexual offenses will also have a punishment which is half to the real punishment which is prescribed for that offense. So that's about abetment. And what is the procedure for reporting cases involving the sexual offenses? First thing is that if such an offense is committed, it is mandatory to report such cases. Firstly, it should be reported to the local police station or the Special Juvenile Police Unit, that is SJPU. And once it is reported, there should be an immediate action, or the police officer should immediately file the FIR or register the FIR. And after that, the investigation starts. Before that, the thing to be done is the medical assistance. Whenever such an offense is reported, the police should immediately do the medical assistance of the victim. After the medical assistance, the police should report the case to the Child Welfare Committee within 24 hours of the cognizance by the police. And after all, the Child Welfare Committee is to take some necessary actions regarding that. And after the medical examination, actually the child is to be sent to the home. But in case of sexual offenses committed by a member of the family of a person where the child stays, or a person in the child care home, etc., in that case, considering the best interest of the child, the Child Welfare Committee may decide not to send the child back home or the place where child is residing in. Instead, she or he will be sent to the child care home. Now we can look what is the medical assistance in detail. What are all the procedures to be followed during the medical assistance. So immediate medical assistance is to be given. And if it's a female child, a lady doctor should assist or examine that child. And the lady doctor or the medical institution should collect all the forensic material which is very essential for the court to proceed with the prosecution. And in case there's no lady doctor or parents of guardians of the child available, any female staff can be nominated to be present during the medical examination, and that nomination or that appointment or that is done by the head of the medical institution. And after the medical examination or the medical assistance, it's the role of the police to initiate the investigation for the statement of the child. As per section 64 of the CRPC, the statement of the child can be recorded in the language spoken by the child. And the child, it is to make that child comfortable with what all the things that can be provided for him for a child friendly manner questioning. If that police is not able to understand what the child is saying, there's a provision for having a special educator or translators or interpreters to know what the child is saying. And after recording of the statement, the real investigation starts. Another important thing is the kind of failure. If there's a failure to report the commission of offense, already someone knows about the offense and he did not report about the same to the police officer or the special juvenile police unit, then such a person will be punishable with 6 months of imprisonment or fine or with both. And if there's a kind of failure to record an offense from the side of the police officer or SJPU, in that case, the punishment provided will be 6 months imprisonment or fine or both. Likewise, if there's a failure to report by a person who is in charge of any company or institution in respect of offense, that may be a childcare institution or childcare home, etc., and that particular offense is committed by the subordinate under his control, and he did not report the same, in that case, the punishment will be provided 1 year imprisonment along with fine. Another thing is that if there's a failure to report, in case of a child, that a child is a victim and that child did not report about the same, in that case the same is not punishable considering the child's mindset or the victim's mindset. Look, in every cases there may be false complaints. So if there's a false complaint against any person with a malicious intent or bad intention, and then he will be punishable with 6 months imprisonment or fine or with both. If the false complaint is against any child, then the imprisonment will be 1 year or fine or both. And in some cases there may be that if someone presumes that there may be such an act from anyone's part, that is any kind of sexual offense is committed, and in good faith he has reported about the same or given for a complaint, and after that only he recognized that it was just his presumption, and in such case as he has done the same with a good faith, no civil or criminal liability for giving information shall be moved or shall be there. Next important thing is that protection of identity of child. If a child is a victim or the victim's identity should not be revealed. The media is not to disclose the identity of the child except when permitted by the special court. That is any kind of photograph, name, school or neighborhood, etc. Those details which reveals the identity of the child should not be disclosed by the media, and if such an act is done, it will be punishable with a 6 months imprisonment, which may extend to 1 year, and fine. Now, what are the procedures for recording statements of the child? Many of the points were discussed earlier, since even then I will discuss about the same. First, the utmost thing is that any kind of procedures followed to take the statements of the child should be child friendly. The residence of the child should be recorded, and the officer who is recording the statement should not be below the rank of the sub inspector, and the police officer should not be in the uniform. That is so because if he is in uniform, that makes the child panic, and that may cause the child not to reveal what is true. So that's why police officers not to be in uniform. Another thing is that when recording statements, the child will not come. A child should not come in contact with the accused. The child should not come face to face with the accused. Another thing is that child not to be detained in police station night. At night, child could not be detained in the police station. He should be moved to the child care home or to the home itself. And the recording of the statements from the child should be in the presence of the parents or any other person in whom the child has trust and confidence. In case the statements provided by the child is not clear to the police officer, at that time only the assistance of translator or interpreter or special educator can be given. There may be some cases in which the child cannot be brought to the police office or police station. At that time, any police officer will be at the home and he can record the statements using any audio, video, electronic means. That's all about the procedures for recording statements of the child. Then what about the special courts? What is special courts? After these procedures were completed, the child will be taken into the special court. A court of section in each district is to be designated as a special court for speedy trial. In order to ensure the speedy trial, a special court to deal with such cases is there, and that is namely POCSO court. And the state government has a duty to appoint a special public prosecutor for every such POCSO courts. So this is the special court, and what are the procedures and powers of special court? Upon receiving the complaint of facts, even though the accused is not present there for the trial, the court may take cognizance of that offence. Likewise, the child cannot be cross-examined or re-examined through special court. That's such an act is not allowed. And while going on the trial, the frequent breaks should be provided for the child to make his or her mindset to be ready and clear for any kind of questions. Frequent breaks should be provided. And as we said in the procedure for recording statements, here also the presence of parents or guardians or friend or relative of the child is to be there. Child cannot be called repeatedly to testify. Likewise, child cannot be questioned aggressively again questioning, and some kind of questioning which may completely destroy the character of the child. Such questions is not allowed. While the trial of cases in camera can also be done. Here also, if the court is not able to identify the language, if we're not able to recognize the language of the child, assistance of the interpreter or translator or special educator can be taken. In case the offence is committed by a child, such child is to be dealt under the JJ Act, Juvenile Justice Act 2015, in detail Juvenile Justice Care and Protection of Children Act 2015. And after that, the case will be sent to the Juvenile Justice Court. Compensation and also legal aid is also provided for the children. Compensation is provided in case of any immediate relief. Immediate relief is required. Medical treatment is required. Then the compensation is provided. And long-term rehabilitation of child by considering the aggravation of the offence committed or the seriousness of the offence, long-term compensation may also be provided. And at any time the child can approach any lawyer for the free legal aid in case of such sexual offences. Now we dealt with what is POCSO Act and what all are the procedures followed in case of such an offence. But we need to know Who is the monitoring authority in case of these sexual offences? In national level, there will be NCPCR, that is National Commission for Protection of Child Rights. They are here in order to know whether all the kinds of procedures are followed accordingly, according to the POCSO Act itself. If it is implemented okay in all states or center or national wide, etc. And the center and states have the responsibility to spread and give awareness and training to the judiciary or the police, and also give the enough knowledge about this POCSO Act, give awareness to the common people about the same. And that's all about the POCSO Act. Thank you. And next video I will be dealing with some of the important case laws related to this POCSO Act.